My ex-husband spent $47,000 on his attorney. I know this because the billing records eventually came out in discovery, and because the attorney, who was considered one of the better family law litigators in our city, apparently charged in -1 minute increments and was thorough about documenting them. $47,000 to intimidate me. He chose that attorney specifically. I found out later from a mutual acquaintance that he had asked around, that he had asked specifically for someone aggressive, someone who would make the process difficult, someone who would, in his words, take her apart. He had also told multiple people in the weeks leading up to our first court appearance that I had no idea what I was walking into, that I thought I could handle this on my own, that this was going to be a lesson, that he was not entirely wrong, that I knew what I was walking into. He was completely wrong about what that meant. My name is Dr. Sarah Whitmore. For the past 11 years, I have served as a federal judge in the district court of this state. Before that, I spent 6 years as a circuit court judge, and before that, 14 years practicing law, the last 7 of which were spent as a senior partner in one of the oldest litigation firms in this city. My ex-husband knew I had a law background. He knew I had worked as an attorney. He did not know the rest. In fairness to him, I had not told him. In fairness to me, he had never asked. Daniel and I met when I was 34. I had just taken the bench for the first time, my first circuit court appointment, and I was, at that point, deliberately stepping back from the visibility I had built as a litigator. Federal judges operate with a particular kind of institutional invisibility. You are known within the legal community. You are not, generally, known outside it. Your name is not in the newspaper. Your face is not on the news unless something unusual has happened. You are part of a system that functions better when its individual components are not high-profile. Daniel was not a lawyer. He was in real estate development. We met at a dinner party hosted by a mutual friend. He was charming and warm and completely uninterested in discussing law, which at the time felt like a relief. He knew I worked in the legal system. He understood it as a stable, respectable, government-adjacent career. He did not particularly want to know more than that. We were married for 7 years. The marriage had a long, gradual decline of the kind that is very difficult to pinpoint to a specific moment because there was no specific moment, just a slow accumulation of incompatibilities that both of us ignored for longer than we should have, followed by a shorter period during which we both knew and neither of us was ready to say it. When I finally said it, Daniel did not respond well. He had, I think, believed for some time that I was the less powerful person in our relationship. I was quieter than him in social settings. I had a schedule that required me to be careful about what I could and couldn't discuss publicly, which he had always interpreted as a kind of vagueness rather than discretion. He earned more money than me, which in his framework was a significant data point about the balance of things. He had friends. He had presence. He was the one people remembered when they met us together. When I filed for divorce, he was surprised when I proceeded with the divorce without hiring an attorney. He was first confused and then, I think, pleased. He interpreted it as me not understanding what I was in for. He hired the $47,000 attorney. He told people I was going to be taken apart. I should explain something about family law and judicial ethics. A sitting federal judge filing for divorce creates a situation that is handled with particular care. I had recused myself from any cases that created conflicts of interest throughout my marriage, and my divorce was managed with input from the ethics committee of our court. I was not practicing law in my own case. I was representing myself as a pro-se litigant, which is legally a very different thing, but I was doing so with 30 years of legal knowledge and a specific understanding of procedure that most pro-se litigants do not have. I also understood, having spent 6 years on the circuit court bench, exactly how family law proceedings worked in our state, exactly what the standards were for the issues we were likely to dispute, and exactly what kinds of arguments were and were not going to be effective. Daniel's attorney did not know any of this. He knew I had been an attorney. he would have pulled my bar registration, which listed my last firm and the years I had practiced. He would not have pulled my current judicial appointment, because that information is in a different database, and it would not have occurred to him to look. He thought he was preparing to litigate against a woman who had practiced law 20-something years ago and was now doing something administrative in the federal system. He had prepared accordingly. The preliminary hearing was on a Tuesday morning in March. I arrived early, as I always do. I was wearing a navy blazer and carrying a briefcase that I had purchased years ago and still preferred to everything else I owned because of its particular organization. I sat at the table designated for my side of the proceeding and arranged my materials. Daniel arrived with his attorney 8 minutes before the scheduled start time. The attorney, his name was Crawford, Michael Crawford, came in with the particular energy of someone who was accustomed to these rooms and accustomed to winning in them. He was mid-50s, expensive suit, the kind of practiced authority that comes from years of performing competence in front of judges. He looked at the opposing table and saw me, alone, no counsel, notepad and briefcase. And I watched the very slight adjustment in his posture that told me he had assessed the situation and found it favorable. Daniel sat down. He looked at me with an expression I had not seen before in our marriage, something between satisfaction and anticipation. He thought he was about to watch something happen to Emmy. The clerk called the room to order. Judge Patricia Holloway walked in. Patricia Holloway and I had known each other for 19 years. We had overlapped at the circuit court level before she was elevated to the family division. We had served on 2 committees together. We had spoken at each other's investiture ceremonies. She had sent me a card when I was appointed to the federal bench, and I had sent her one when she was elevated. She was a careful judge who took conflicts of interest seriously. She had, in the weeks before this hearing, reviewed the case assignment and determined that our professional relationship, while real, did not create a disqualifying conflict, that our interactions had been entirely professional, that there was no financial or personal entanglement, and that recusal was not required. This determination was documented. She sat down. She opened the file. She looked up at the plaintiff's table, Daniel's side, and then she looked at the defendant's table and she saw me. She is a very controlled person, Patricia Holloway. Her face did not change significantly, but there was a quality of attention that shifted, a slight settling, a professional registering of something unexpected. Crawford was already on his feet, beginning his introductory remarks. The practiced opening of a litigator who had been doing this for decades. Judge Holloway let him get approximately 4 sentences in. Then she said, "Counselor." One moment, Crawford stopped. She looked at him over her glasses. She said, "Before we proceed, I want to make sure the record reflects something. Are you aware of your opposing party's professional background?" Crawford said, "She's a former attorney, Your Honor, retired from practice approximately." "Not retired," Judge Holloway said. "Currently serving." A pause. "Do you know who this woman is, Counselor?" Crawford looked at me. I looked back at him. Judge Holloway said, "The opposing party is the Honorable Sarah Whitmore, United States District Judge for the Southern District of this state. She has been on the federal bench for 11 years. Before that, 6 years on the circuit court. Before that, 14 years in active practice, the last 7 as senior partner at Whitmore and Associates." She looked at Crawford over her glasses. "I would adjust your approach accordingly." Crawford's face did not collapse. He was a professional. But there was a distinct moment, approximately 2 seconds, during which he was processing information that had not been in his file. He looked at Daniel. Daniel looked at me. I want to be precise about what I felt in that moment, because I have been asked about it many times since. I did not feel triumphant. That is not the right word. I felt something more like the completion of a circuit, the closing of a loop that had been open for a long time, not just since Daniel filed his counterclaims, but since much earlier, since the years of our marriage during which I had been, in his framework, the quieter one. the one who deferred in social settings, the one who let him lead conversations because leading them wasn't something I needed to do outside of a courtroom. I had never hidden what I did. I had simply never performed it. And for 7 years, Daniel had confused the absence of performance with the absence of substance. That confusion was now resolved. The hearing proceeded. Crawford adjusted his approach, as Judge Holloway had suggested. He was still competent, he was genuinely good at his job, but the quality of his preparation had been designed for a different opponent. And that showed in the specific places where his arguments expected gaps that were not there. I was not cruel about it. I want to be clear about that. I was not in that courtroom to embarrass Crawford or to perform. I was there to represent my interests accurately and effectively, which is what I did. There were two substantive legal issues in our preliminary hearing. I addressed both of them with the specific case law and procedural knowledge the 20-plus years of practice gives you. Crawford objected twice. I responded to both objections correctly. Judge Holloway sustained one, overruled one. The hearing lasted 2 hours and 20 minutes. Daniel said nothing during the entire proceeding. He sat at his table and listened. Once, approximately 90 minutes in, I looked at him directly, not to make a point, just as part of the natural movement of the room. And his expression was not the anticipatory satisfaction it had been when he walked in. It was something I had not seen on his face very often during our marriage. It was uncertainty. In the hallway outside the courtroom afterward, Crawford found me. He was professional about it. He said, "Your Honor, I want to apologize for I should have done more thorough due diligence before." I said, "You did your job, counselor." "So did I," he said. "If I may ask, did you know I hadn't?" I said, "I assumed you had done standard research." "What that research shows depends on where you look." He was quiet for a moment. Then he said, "This is going to be a very different case than my client was led to believe." I said, "I imagine that's a conversation you need to have with your client." He said it was. Daniel called me that evening. "It was the first direct call between us since before the filing," he said. "A federal judge?" I said. "Yes," he said. "For 11 years." I said. "Yes," he said. "You let me believe." I said. "I let you believe what you chose to believe, Daniel. I never told you I was something other than what I am. You never asked what I actually did." He was quiet for a moment. He said, "You knew what you were doing when you filed without an attorney." I said, "I knew I was capable of representing myself effectively." "Yes," he said. "This isn't what I thought it was going to be." I said, "I know," he said. Crawford says. I said, "I think you should listen to Crawford." The divorce was finalized 7 months later. I am not going to detail the settlement because that is private. What I will say is that the outcome was fair, not favorable to one side at the expense of the other, but fair in the specific sense of reflecting the actual facts of the marriage and what each of us had contributed to it. Crawford, to his credit, became a reasonable opposing counsel once he understood who he was opposing. The $47,000 stopped at some point. I don't know exactly when, and the tone shifted from aggressive to professional. Daniel and I have not spoken since the finalization. I don't have particular feelings about that. We had a marriage. It ended. We are both different people now, in different phases of a life that no longer involves each other. What I think about most is not the courtroom moment. It is not Crawford's face or Judge Holloway's perfectly calibrated delivery of my credentials. What I think about is the 7 years during which I was, in Daniel's framework, the quieter one. I was not quiet because I had nothing to say. I was quiet because I had learned in the specific environment of the federal bench the value of saying exactly as much as the situation required and no more. Judges do not fill silences. They do not perform their authority. They sit with it and they use it when it is needed. And they put it away when it is not. Daniel interpreted that as smallness. It was not smallness. I want to ask you something. Have you ever been in a room where someone was performing their certainty about who you are. They're settled, confident, well-prepared certainty, and you have known quietly that the performance was based on incomplete information. And have you chosen, in that moment, not to correct the record? Not out of deception, not even out of strategy, necessarily. Just because the moment wasn't right, or because correcting the record would have required a kind of self-promotion that felt alien to who you were. Or because you had learned that some rooms reveal their own truths eventually, without you having to manage the reveal. Tell me in the comments, because I think a lot of people live in that space, the space between who they are and who the people around them think they are. And I think the distance between those two things is sometimes a problem, and sometimes a practice, and sometimes, in the end, a kind of patience that eventually pays for itself. Tell me which one it has been for you.